Wile.
Mr. McLean?
Good morning, Your Honor. May it please the Court, Sandra McLean. I represent the appellant, Evan Wile. With me at the counsel table is my partner, John Griffin. This case is a case of nuisance only. By agreement, all other claims were removed prior to trial. In addition, it is clear that the nuisance arose out of an unhappy many-year relationship between two neighbors. In fact, since 1992, when my client purchased his property, there's been less than a year in which he has not been subject to litigation commenced by the plaintiffs below the appellees. At some point in the testimony at trial was August 1999, my client began to engage in some activities to which the plaintiffs objected. And the plaintiffs went to trial on the theory of nuisance only, and that's where we start, with the standard of what is a nuisance. It's clear from the record my client brought various things on the property that the plaintiffs objected to. The standard of nuisance, which we fully accept, when a condition or activity on my client's property, Mr. Wile, quote, causes a substantial and unreasonable interference with the use and enjoyment of the property of another, Doe versus New Bedford Housing Authority. The critical thing to us is the conjunction of use and enjoyment. In this case, we're not challenging the subsidiary findings of the trial judge, and there were some factual findings in two contempt trials which had taken place prior to the trial. The part that we are challenging is whether those subsidiary findings, the kinds of things that happened, number one, do they constitute nuisance as a matter of law? And number two, what is the correct remedy for them?
May I just interrupt just by way of background? I want to make sure I've got this right, that some of the items included a pickup truck, a dinghy, truck tires, portable toilets, and is it correct that the judge found that the toilets were in the view of the...
Well, they were on the property line, weren't they?
They were on the property line.
They caused their odor to invade the other person's space?
Well, there was testimony at trial which the court accepted, that on occasion the odor from the portable toilets went across the property line, and in that general vicinity there is an outdoor swimming pool. And there was testimony.
An outdoor swimming pool on the...
On the Horvitz property, on the neighbor's property.
Well, that at least would be classic nuisance.
There's no question about that. The odors and I believe the landing of the helicopter, which in addition to my client's a licensed helicopter pilot, and he had FAA permission to land there. But it's noisy, and when it comes down, it throws debris. And those, I believe, could be found to be classic questions of nuisance, and we don't challenge that. The problem is that those incidents, the portable toilets, which is the odor, a standard nuisance kind of thing, and the noise and the debris from the helicopter, again, could be a standard nuisance kind of thing, were rare occasions. The judge awarded damages for 13 summer weeks over a 5-year period, a total of 65 weeks. But there's no finding that the helicopter landed after the complaint was filed. There was an immediate preliminary injunction which prevented landing of the helicopter, and so that didn't happen again. And as to the portable toilets, the finding was that that had happened on 2 occasions.
Could I ask you that with regard to the other things? You know, sometimes people should, pay attention to whether they're succeeding in bringing about what they intend. It would be a fair inference from all of the evidence presented that the defendant intended, wanted, desired to interfere with his neighbor's use and enjoyment of his land. And, why can't the judge say he succeeded? He succeeded in his objective by making, all these unsightly things, around. He did it to bother his neighbor, to interfere with his neighbor's use and enjoyment. That's what he was trying to do. So I find that he succeeded.
Two things. Number one, there's a portion of the judge's findings which she dictated and are in the record, in which she said she didn't believe that it was necessary to reach a conclusion as to the purpose for which that was done.
No, because
because
typically, I mean, when I read that, I mean, she's essentially, that doesn't change Justice Sussman's characterization of it. I think what the judge was saying, I don't have to go there because that's not an element that I have to establish. I mean,
fair. That's a fair comment. And I agree with you, this is grown men behaving badly. However, the question is whether it's the tort of nuisance. And I'd submit that bothering your neighbor does not give rise to the level of a nuisance. You must, as a conjunctive, you must interfere with the use and the enjoyment. This may have interfered with enjoyment. There was testimony by Mrs. Horvitz that she didn't like seeing the things, and when she came out and looked at them, it made her very upset. The being very upset is not one of the elements of a nuisance. It must interfere with the use and enjoyment.
But how is it really, I mean, deep down, that different from odors? They come down to aesthetics.
Precisely.
They come down, but so do odors. Some people don't mind the smell of a cow barn. They think it's, in fact, a wonderful, idyllic country smell, and other people, it drives them nuts.
Some people don't like the smell of baking bread, and they try to shut down the bakery. And
there's an SJC case which talks about that and says we don't measure nuisance by the most sensitive or the most robust.
No, but this wouldn't take the most sensitive of neighbors to not like the stuff that Mr. Wile was doing and the stuff that he was putting up along the property line. It seems to me that merely saying that, well, it interferes with aesthetics and only aesthetics, therefore it's not nuisance, is not helpful, because other aspects of nuisance at their core are in fact about aesthetics.
I would suggest to Your Honor that that's not the case. And if you look at the kinds of cases which traditionally nuisances have been found, noises, bright lights, odors, vermin, are things that are actually invading your property.
Mr. McLean, I understand that, but there's also been a whole development of the law on the other side. It's now perfectly permissible, which it wasn't when, Prosser wrote his book on torts, for zoning boards, for zoning laws to take into account, quote, aesthetic, in other words, architectural limitations. I mean, so it's not the most sensitive, but there are developments in the law that say if you have a property and you, as I understand the record here, they were unsightly to the plaintiff's items placed on, no smells, no noise, no dust, just unsightly, really unsightly. Maybe they were porta toilets which nobody used, so no smells, but obviously unsightly. They build a 6-foot fence, as I understand it. That's a fair, so they can continue to use and enjoy. In other words, if lying next to the swimming pool happens and you don't use it because you can't enjoy it, and then your neighbor says, well, what I'm going to really do is take all of this unsightly stuff and put it above, can't a 21st century court say, that's not conduct that we're going to condone. We're just not going to condone it.
I think you can say that, but the question which was raised in this case was solely one of nuisance. This wasn't a case of zoning, and by the way, there have been zoning complaints about my client's behavior, and much...
I'm talking about within a nuisance case. In other words, one way to deal with this is to go to the state legislature or to your local Board of Appeals. But another way is to say there's a classic way that the common law has recognized for centuries, which is when you've got private parties engaged in a dispute, and at some time odors was new law. We're going to say unsightly things which, not just out of the blue, but was drawn to the attention of the plaintiff. There was no need to the defendant, no need for the defendant to have that. In other words, this is not as if he's operating a school, but there's no need for him to use his property in that way. As Justice Sussman said, the sole purpose appears to be to make the life of his neighbor impossible.
I would say the inference was not to make the life of his
was it
neighbor
to
impossible, but to
Interfere with
push
the-
back. To push back after years of having been sued. My client still has vacant property that he's been trying to develop for 13
But
years.
that's because of local zoning requirements, correct?
Not originally. Originally, there was other litigation. More recently, there's been a zoning issue. But we have to get back to whether what he did was tortious.
If we get into this area, though, could we not get the Superior Court into intolerable situations? Someone could put up a statue in his or her yard, which he or she thinks is art, and the neighbor is offended. And we might even, we don't want cases over that, and also we might get into First Amendment problems if we hold that unsightly objects can constitute a nuisance.
To my knowledge, that issue came up in Wayland recently and was dealt with as a zoning
United
issue,
States
as to
Supreme
whether artwork on the front lawn was offensive to neighbors
The
or
United
not.
States Supreme Court has suggested in its own opinions that, yes, indeed, even though there are powerful interests represented in the First Amendment, there are limitations that towns and cities can place on that.
And we don't, but this isn't a zoning case.
No, but the court is no different. In other words, if it's a matter of a First Amendment concern, there are ways that those can be dealt with, and I think that there are limitations that have been, you can't just say you can't have anything. Here, it's not a question of whether it was a choice of a piece of sculpture or whether it was something which there might be a division in the community as to whether this was good art or bad art, whether it interfered with the view or didn't interfere with the view. I mean, these were objects where there was no beneficial interest of your client.
I'd suggest to Your Honor that it has never been the test or the sole test or the touchstone of nuisance,
It's
whether
not
it
the
was
sole-
beneficial or not.
Oh, no, it's
Well,
not the
for
s-
example, flooding cases.
It's not the sole test, but we have been very careful when, for example, that one client, one owner of property has been using its property in a way, older cases are the most obvious. You're operating a bakery. Or you're next to a sweet factory. And courts can take that into account, and they don't ignore what is happening by the owner of the property. It seems to me that this is perhaps the cleanest case. This is not a neighbor objecting because you've put a statue in the middle of a house, in front of a house.
I think that's correct, and in that sense, it is a clean case, but I need to take you back to the elements of nuisance. This did not interfere with use of the property. It offended the sensibilities of the plaintiffs.
Well, let's assume that somebody doesn't go and use their swimming pool. Perfectly proper to have a swimming pool. They don't use the swimming pool because they don't want to look at toilets that serve no function.
And I would say, first of all, the toilets, using the toilets as an example, they served a function. The problem was where they were placed on the property.
Did the judge make any findings about use?
About the plaintiff's use?
Correct.
No. I believe her conclusion was, after reciting the conditions which she found improper, and you can find those recited in the record at 204 and at 207 through 208, she concluded that's the dictated findings. It'll also appear at, I believe,
If she
elsewhere in the
made
transcript.
findings about use, then I think your argument is over and done with.
My memory, Justice Graney, is that what she made findings about was what the conditions were, and then concluded that those things constituted a nuisance.
Was there evidence about use?
There was evidence from Mrs. Horvitz that when she went out and saw the things, she didn't like seeing them. There may have been evidence, and I don't recall precisely, that it interfered with her desire to use the pool.
Tell me,
which was on
did
the
the judge
property.
take a view?
She did.
Yes.
And do we have photographs?
There are some photographs. You will find them in the back of the record. There are the photographs that were introduced at trial were reproduced in color. They're a little easier to see. They appear at the back of the record.
She found, I'm looking at her findings on page 31. I find...
Excuse me, page, which page?
31 of her findings. I find that they did cause the plaintiff and their guests and family members emotional distress and harm by way of the inability to enjoy and use the property to its fullest extent. Now, I don't know whether you challenge those as clearly erroneous, But that's what I've got.
Your Honor, on a nuisance appeal, I'm allowed to challenge whether the facts as found are legally sufficient to constitute a nuisance. And I'm clearly challenging that. We're arguing that aesthetic considerations, without more, cannot constitute a nuisance. We've cited a number of cases. They're not from Massachusetts.
I understand that, but I was going to your point of you saying we have to have use and enjoyment, and here, it may have interfered with the enjoyment. She's got a finding of fact that there was use, that the use of the property. Use of the property, by the way, doesn't necessarily mean that you can't sell it or you can't rent it. That's a powerful indication. That's a powerful indication, but it's not the only indication.
May I use that as a jumping-off point to very briefly deal with one other issue relating to the measure of damages for the interference? Mm-hmm. The measure of damages adopted was lost rental value, although there was no evidence they had ever attempted to rent the property, and there was no evidence that the interference had prevented them from living at the house. They had never attempted, they had never moved out of the house.
We use diminution in value. Say sale value. Somebody has no intention to sell the property. It's just, how do you put this in dollar terms?
I would suggest on a diminution of property value, that's because someday you will go to sell the property.
But if we adopt your argument, then it's...
Cured someday, but...
But if we adopt your argument, then how do we measure damages if a normal homeowner, if we have the normal homeowner situation and he or she never intends to rent?
I would suggest to Your Honor that you cannot measure it in a way that results in an economic windfall to somebody who continued to live in...
But how do we measure it?
I would suggest that damages weren't appropriate in this case. The injunction did everything it needed to do. It prevented the harmful activity, and it required him to remove everything that was within 20 feet of the property line. From 20 feet to 40 feet of the property line, he couldn't go higher than 6 feet with anything, and he wasn't allowed to land the helicopter. I'd suggest that if the court had stopped there, everything would have been done. The activities they objected to would not have happened anymore.
The plaintiff had to go through the expense of hiring attorneys, all the aggravation of a court suit for all these years, and all it gets is an injunction for your client to do what he should have been doing in the beginning, which is nothing?
Your Honor, injunctions are entered for that purpose all the time, but at the outset of this case, at the very outset of this case, they had an injunction which protected them from the landing of the helicopter. The permanent injunction, from the brief I argue, goes too far in talking about harassing activities. But the permanent injunction, if all it had said is remove the materials and don't land the helicopter, would have given them 100% of everything they needed. That's why you grant injunctive relief in a case like this, because economics don't work.
Did the plaintiff's expert testify that $6,000 a week was the fair rental value of that property?
No. What he testified to was that in his estimation, which he admitted was unscientific and unobjective, that the fair rental value was $8,000 if there were no problems in the neighborhood, and that with problems in the neighborhood, the fair market rental value was $2,000. The difference of $6,000 is what the judge adopted as the proxy, and she applied that to every week in which she claimed, she held that there was a nuisance.
Did the expert identify what the problems were that would reduce it from $8,000?
No. In fact, that's one of the things we objected to. What the expert testified to was that he once toured the inside of the building. He once toured the outside of the building. He was shown some photographs, and that wealthy people wouldn't want to rent in a place like that. So there was no way to identify whether the diminution in rental value was because of a helicopter or odors from toilets or an unsightly sign or some construction debris or a trailer, all of which were intermittent.
Thank you, Mr.
Thank you.
Please the court. My name is John Connolly. With me is my associate Kevin Gainey. We represent the plaintiffs in this matter.
Isn't this to a large extent a state of mind case? Your opponent said that his client wanted to push back at these people. So wasn't the theme of this case, I'm going to make their life miserable by doing these things?
Well,
and that seems to me to equate with an aesthetic nuisance.
I think it's fair to say that that the trial judge made that finding, and that it is even now unopposed. So
I don't see anything wrong with that finding, based on the evidence.
That he felt entitled to push back, and that he was motivated by a desire to injure my clients?
Yes.
Yes.
Almost by malice.
Yeah, I think that's true. I think that's exactly what happened, and I think the judge found it.
What if the motive weren't present in this case, and you simply had somebody that didn't mow their lawn, that put toilet seats out on the property, a boat, something that was short of a junkyard that was permissible under the zoning ordinance? Would that be a nuisance?
I think there'd be circumstances where it would not be. It would really depend on a matter of degree and placement and all of those issues. This case, even my brother admits, is a clean case for making a determination because there was malice, obvious malice. The actions were something that, first of all, this property is ultra-private, both lots. His is vacant. My client lives in a beautiful home, and it's very private in a very exclusive area, very valuable. Mr. Wile, and it's in the record, attempted to sell his vacant lot to my client for $2 million. So we're talking about very valuable property. He selected his victim, and now he's paying the price for
Mr.
it.
Connolly, two questions. First, let me ask not the easier one, but why is not injunctive relief, broad injunctive relief, adequate here? In other words, to the extent that the court is interested in entertaining relief from what appears to be a malicious intent, which is not really part of nuisance law, but says whatever the nomenclature is, this is obviously an attempt to interfere with the use, enjoyment, and property value of my neighbor. Why isn't injunctive relief adequate?
I think if it were done within the first week, it may have been adequate. But these people had to live with, and by the way, the toilets were there for at least 2 full summers right next to the swimming pool, and I mean you couldn't put your hand between the fence and the back of those toilets, and they were used regularly, and the odors were there regularly. The only time we didn't have odor that really prohibited the Horvitz family from using and enjoying their property was when the wind was blowing in the right direction.
In the other direction, you mean away from
Away from the correct direction. So this description about, they weren't used, they were used all the time. They stunk all the time. And there isn't any question about that.
So
the rubbish was there all the time. There was a trailer pushed against the fence. And this happened not every day. Everything didn't happen every day. This happened over a period from 1999 through and after the date of the trial. In the record, you'll see that the defendant, Mr. Wile, was found in contempt of the permanent injunction in May of 2004. So even when the judge gave my client what we think are reasonable compensable damages for the nature of the neighborhood and the nature of the people involved here, even then, he didn't stop. There was a later finding of contempt. And it's in the record, it's right in the docket that the defendant put in the record, where Mr. Wile was found to be in contempt of the trial judge's permanent injunction.
It seems to me that most nuisance cases are really concerned about a theory of trespass, about a continuing trespass. There's noise that spills over, there's dust that spills over, there's light that's shining, intense light that's shining directly onto the other person's property. And there's some of that here with the helicopter and the toilets. There are some other things that I'm a little concerned might not qualify as a nuisance, or perhaps shouldn't qualify a nuisance in other kinds of cases. And maybe the way around it is the intentional nature of the tort here.
Well, I think if you look at the restatement, which we think is a good source of law in this case, or a good standard to set, the restatement breaks it down in a way so that the court can evaluate motive. It says, it takes a look at what the action is, and it weighs the action. It says, does this perpetrator, is what that person doing, does that have a value to him and his property?
Yes, that's been long established. That's my bakery case.
Right.
If you have the right under the zoning laws to operate a business, and you choose to operate, a bakery, and I use that because, I would say that most people like the smell of baking bread But not everybody wants to have the smell of baking bread all the
Right.
time.
But if you do it maliciously, Your Honor,
Correct.
if your goal is to injure your neighbor, then your action's not protected, it has no value, and then it slides over to what is the effect on your victim? What's your effect on your neighbor?
And these cases, it seems to me, are very context-specific.
They have to be.
Yes, you can't be talking in the broad generalization, well, if somebody puts a construction trailer or a construction debris holder too close to the other guy's yard, that that's automatically a
And
nuisance.
Mr. Wile's looking for a bright line test.
Yeah, and there's
You know,
no
if it's
such thing.
aesthetics, you can do anything you want.
You've got to see
What's that turn into?
exactly what occurred here, where its location was, what was Mr. Wile's motivation, which everyone seems to concede was at least intentional conduct, maybe malice, and analyze it. And further, use and enjoyment, I think that's an alternative test. It can interfere either with the use or with the enjoyment.
I agree with that, Your Honor,
And I think the case
restatement
is
does.
probably so hold. I think the restatement so states. So to get bound up in this, you got to have both. Seems to me to be immaterial.
I think that's correct.
Mr. Connolly, let me ask you this. I haven't had a look at your complaint, at your client's complaint. Did you plead any causes of action other than nuisance?
We did, Your Honor. We pled trespass, waste, and surcharge of an easement. Those three counts were removed to the land court and consolidated with a case that relates to Mr. Wile's attempt to put a subdivision road in.
Okay.
So those were removed, and there was an agreement amongst the parties that it was going to be tried to the court, and it was going to be just the issue of nuisance.
Okay, because I'm looking at the judge's permanent injunction, and again, I understand the context in which this case arises, but she says he's permanently enjoined from anything knowingly causing, permitting any activity to take place on or about his property that harasses plaintiff, his family, or guests, or to commit any acts of harassment. Was that was that based on a submission? I mean, it seems to me that
Was it a request on our
Yeah.
part? I honestly don't remember whether we requested an injunction. I'm not sure that we provided a draft of that. I don't think that we did, actually. But the judge...
she then goes on to define it. I
And
understand.
basically, it warns Mr. Horowitz not to abuse the order, and says if he does abuse it, you know, he's going to end up back in court, and the judge will alter the order. I mean,
When did you file your complaint, roughly? What year?
I think it was in
This complaint?
2001, I think, Your Honor. It's right in the docket.
Well, that's fine, because what I'm saying is...
February of 2001.
Okay. So this is running at 48% interest right now, correct? This award?
It's
Full
yeah, it's
percent
carrying-
times 4.
It's yeah, it is, Your Honor.
The land court case still pending?
It is. The zoning cases are over. My brother referred to zoning cases. There were zoning cases. Mr. Wile was granted a building permit. That was denied. That was allowed, then revoked, in summary judgment in the land court, then an appeal court, and this court last week declined to hear the case. So the property is not buildable. It's a vacant piece of property in a beautiful area, and there really isn't any reason.
What's here is parcel number 2?
It's the smaller one, yes. Yes. There are houses all around it. And there's testimony in the record, by the way, that this pile of rubbish that was right at the turn where you come from a long, very private driveway to face my client's property, Mr. Wile testified in the trial that another neighbor had come to him and complained that they couldn't sell their house because there's a house right between Mr. Horvitz's property and West Street. They couldn't sell their house because people were coming and looking at it. So the thought here in the testimony from the expert was not as described. The expert testified that this is a unique and valuable, extremely valuable piece of property. He had done comps. He had viewed the site. He had seen photographs of all of the things that were wrong and witnessed some of the stuff that was still there. And his feeling was that the property was not rentable to someone who could afford to be there because they're interested in privacy and not being bothered. And it was an obvious intent. The judge found a campaign on Mr. Wile's behalf to create a difficult and destructive neighborhood. That finding, by the way, is not challenged either.
The injunction, the permanent injunction, prohibits essentially anything other than current vegetation more than 6 feet high within, I think it's 25 feet of the
I
boundary.
think it might be 20 feet.
20 feet of the boundary. Is, under the zoning law, would Mr. Wile be permitted to plant trees that would grow higher than 6 feet tall?
I
alongside?
believe he would, and I think that the court invited him to come back for permits if he wanted to do something like that.
But does the town regularly issue a permit for planting a tree?
No.
But it seems to me that before he does anything, he's got to go back and get court permission, unless you folks consent to it.
Well, it's
Or
unfortunate
clearly
that it's come to
within.
that, Your Honor, but he's been so creative in his efforts to,
Or unless it's clearly within a permitted use in
Exactly.
the zoning bylaw.
exactly.
He says that that damages were awarded for June, July, and the first week of August of 1999, and for the month of August, I think, of 2003, which was a month after the opinion, the judge's decision was rendered, and for a period of 9 weeks before which there was even a complaint for damages. That all adds up to about $81,000. What do you say about that?
Well, unfortunately, none of us here really knows what the trial judge thought was when she assessed the damages.
But there was no evidence. I take it you weren't even complaining about anything that occurred in June and July.
The judge actually made a finding, and I can't cite it for you, but
what
it's
was
in
the
there.
basis of the finding if there was no evidence that anything occurred
Oh,
during
there
those
were
2 months?
there were things that occurred. Mr. Horvitz, in the course of his testimony, wasn't pushing it, but there was some testimony about surveyors' stakes being pulled out and driving across lawns and that kind of stuff. But it wasn't pushed. The judge, the plaintiff here, the defendant, Mr. Wile, had a lot of opportunities in the course of this case to do the right thing and uniformly decided not to. He picked the strategy to try to bother Mr. Horvitz and his family and their property. He picked a valuable property. He picked someone who could afford to fight him. That was his mistake.
Could I ask this in terms of the weeks? I gather that she awarded nothing for the fall, winter, and spring months.
That's correct.
Was there evidence that nevertheless some degree of nuisance was going on from time to time during those?
In fact, she found the same, Your Honor. She found that there was 52 weeks of nuisance in the years, I think it was 2001 and 2002, 30 weeks in 2003, and 20 weeks in 19...
But she limited her
99.
damages simply to the summer because that would be the more valuable rental period kind of thing in this community. Was that your thinking?
It appears to be that way, Your Honor. But again, another one of Mr. Wile's strategies, which has amazed me from the beginning, is that all of the discussions you've heard today about their side of the case, you're the first people to hear them. The trial judge didn't hear them. There were no requested findings that related to intrusion, aesthetics, or any of these issues. The measure of damages, they did hardly any cross-examination at all on our expert witness. Didn't even challenge his capacity as an expert. So now they raise all these issues, including the damages claim, which, quite frankly, Rule 59 is set up to deal with a situation where you have a claim of an excessive award, or you have a question of an inconsistency for the trial judge to work out, especially on a jury waive basis. And in this case, excuse me, Your Honor, they had not 10 days to file a Rule 59 motion. They found out about the decision on July 29th. The judgment in this case didn't get entered until, I think it was October 3rd. So they basically had 10 weeks to weigh the wisdom of a Rule 59 motion. And this Court has found in the past that when somebody doesn't avail themselves of Rule 59, they shouldn't bring it up for the first time here.
Mr. Connolly, let me ask you a related question. Has the defendant challenged the scope of the injunction? Because I have to say that it may be that this is not a buildable lot. It may be that there's conduct here which supports an injunction or maybe even damages of some extent, but the notion that you essentially depriving the owner of property of all uses, I mean, planting plants, for example, or saying that you can only have people come onto the land who are related. I mean, I know of many circumstances where people, perhaps not for harassing reasons, will permit their seaside land to be used for charitable purposes. I mean, it seemed to me that read literally, that injunction covers anything other than what currently exists on the land.
I think, Your Honor, that I think you may be reading it a little more
My question is,
broadly.
have they challenged the breadth of the injunctive order,
Has who challenged it?
the defendant?
Not prior to this appeal. And they
They
didn't-
did here, in
They
their
did
brief
here.
yeah.
Yes, they did in this appeal. They didn't even raise the issue in the course of the trial, and they filed no requested rulings or findings that would impact on the scope of the
Yeah, but
injunction.
if the judge issues a very, very broad injunction,
Mm-hmm.
it's not clear to me, and you take an appeal from that saying this is too broad, it's not clear that you have to do anything else.
I was talking really about the damages issue.
No, I'm talking about the
Right.
scope
On the
of
injunction issue, I'm not saying that they couldn't appeal that. I think they probably did the right thing on that one. I do think, however, that, the appeal, the injunction is not that broad, and it's a response to Mr. Wile's creativity and his ability to harass the Horvitz family.
Thank you, Mr. Connolly. We'll take a short break.
Thank you very much.